Okay. Good afternoon, everyone. Good afternoon, everyone. Can we all hear me? Good afternoon. You're welcome to this webinar. Thank you for joining in. Please kindly note that we're about to start and start very, very shortly. Okay, kindly introduce yourselves by dropping a comment, stating your name, organization, and location in the chat box. While as you come in, please. Thank you very much. We'll start very soon. Thank you for your time.
Hello. 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 Hello.
Good afternoon, my lord. Good afternoon, my lord. You're welcome, my lord.
All right. I hope I'm on to you now. Can you hear me now?
Yes, my lord, we can hear you. Yes, my lord, we can hear you. So we'll start right now, my lord.
All right, so please let's start.
Okay, my lord. We welcome everyone again to this webinar. Like we said earlier, kindly please introduce yourselves by dropping a comment stating your name, organization, and location in the chat room, in the chat box. A poll will be sent out shortly, and we'd like you to please respond within a minute of sending out the poll. Thank you very much for your feedback. We'll start now. Can you also the poll? Okay. Okay, so while we wait, while we allow participants to please respond to the questions, I'll just go straight on to the program for today. The Honorable Chief Judge, my Lord, Honorable Justice Kazeem Olariwaju Alugba, the Honorable Attorney General and Commissioner for Justice, Lagos State, Mr. Moyosori Onigbajo, SAN, Honorable Admin Judges of Lagos State, my Lord, Honorable Justice T.A. Oyinkan Abdullahi, my Lord, Honorable Justice O.A. Paye, Chairman, Lagos Multi-Door Courthouse Governing Council, my Lord, Honorable Justice Jumoke O. Pedro, Chairman, the Lmdc Governing Council Litigation and AGR Committee, my Lord, Honorable Justice L.A.M. Folami, Judges of the Lagos State Judiciary, the Acting Chief Registrar of the Lagos State Judiciary, Mr. C.A. Elias, Magistrates of the Lagos State Judiciary, distinguished members of the Lagos Multi-Door Courthouse Governing Council, the Acting Director of the Lagos Multi-Door Courthouse, Mrs. Achere Cole, management and staff of the Lagos Multi-Door Courthouse, distinguished participants, ladies and gentlemen, good afternoon, everyone. Thank you for joining us for today's webinar, themed the Lagos Multi-Door Courthouse Restorative Justice Youth and Juveniles Reform Program. My name is Olubusola Ojo. I'm the Registrar of the Lagos Multi-Door Courthouse, and I'll be moderating this webinar. Just a little housekeeping before we get started. Like we said earlier, kindly introduce yourselves by dropping a comment stating your name, organization, and location in the chat box. If you have any questions during the presentation, please type them into the chat box in your Zoom control panel. The questions will be addressed at the end of the presentations. You can also raise a digital hand if you have questions. Kindly please direct your questions to specific speakers you wish to answer the questions asked. Each of our distinguished speakers have 15 minutes to make their presentations. It's an absolute honor to welcome the Chief Judge of Lagos State, Honorable Justice Kazeem Olariwaju Alugba, to give his opening remarks. My Lord.
Well, good afternoon once again. And for brevity of time, let me say all protocols already established, I adopt. It gives me great pleasure to welcome all of you distinguished persons to this program, the Restorative Justice Webinar, organized by the Lagos Multi-Door Courthouse, Lmdc, whose theme is the Restorative Justice Youth and Juveniles Reform Program. As we will all remember, at the last outing of the Lmdc, this new program was rolled out, was duly introduced and reasonably discussed at that particular occasion. And I think by now all of us must be aware of what it is all about. And this webinar, therefore, is a forum for key stakeholders in the justice delivery sector to discuss the salient issues around the social impact of restorative justice on the criminal justice system and the society, and also to deliberate on the most effective approach for deploying the Lmdc Restorative Justice, Youth and Juveniles Reform Program. It's not easy to pronounce that, the abbreviation easily, so I better state out the full terms. The Lagos State Judiciary has been at the forefront of pioneering groundbreaking innovations and programs in the furtherance of Goal 12 under the Human-Centered City pillar of the Lagos State Developmental Plan 2052, which is an approach to ensure a secure environment and accurate perception of safety in Lagos by ranking in the top 5 of the cities to live in Africa. And to this end, therefore, the Lmdc RJYJRP is targeted at transforming and reforming youth and juveniles in Lagos State through carefully designed projects. The program is also aimed at ensuring quick dispensation of justice, decongesting the court dockets of minor offenses, and decongesting correctional facilities, and reintegrating such young offenders back into the society. I enjoin you all to listen with rapt attention to the presentations by the different seasoned and erudite speakers who will be discussing various topics on the main theme, restorative justice. Once again, let me welcome you all, and I wish that we all have a fruitful deliberation. Thank you. God bless. Thank you.
Thank you very much, my Lord, Honorable Justice Kazeem Olarewaju Alugba. We are grateful for your words and your time at this webinar. Thank you very much. Now we begin with the presentations, and then I'll be reading out the profile of our first speaker, Honorable Justice Jumoke Olushola Pedro. Honorable Justice Jumoke Olushola Pedro attended the prestigious University of Lagos, Nigeria, where she obtained her LLB with a second-class upper division in 1980. In July 1981, she was called to the Nigerian bar to practice as a barrister and solicitor of the Supreme Court of Nigeria. She practiced briefly between 1982 to 1984 as a legal practitioner with the reputable firm of Akin Olugbaje and Co. After completing her NYSC as a legal officer with the Military Police Apapa Cantonment. In 1984, she joined the lower bench of the Lagos State Judiciary as a magistrate. She served as a registrar of titles in Lagos State and rose through the bench to become a chief magistrate. In 1999, she was appointed the chief registrar of the High Court of Lagos and served as the probate registrar, the sheriff, the tax master, and the official receiver in 2001, she was appointed a High Court judge of Lagos State and has served in that capacity ever since. She has worked in various divisions of the court: general civil, family and probate, commercial, fast track, land division, AJR track, and once as a designated judge of the Economic and Financial Crimes Commission matters. She is the author of the book, The Living Law. Her Lordship is a member of the International and National Association of Women Judges Association. She's a member of the Olav Baden-Powell Society and a fellow of the Chartered Institute of Arbitrators, Nigeria. She's also a member of the Chartered Institute of Arbitrators, England, and a certified mediator. She's presently the chairman of the Governing Council Lagos Multi-Door Courthouse. She is the Grand Matron of Federation of International Women Lawyers, FIDA, Lagos branch. Her Lordship is a deaconess at the Guiding Light Assembly and a chancellor of the Church of Nigeria Anglican Communion. She's married to Otuba Olufemi Pedro, a former deputy governor of Lagos State, and they're blessed with children and grandchildren. It's a privilege to welcome Honorable Justice J.O. Pedro as she takes us on the topic, social impact of restorative justice on the society, role of the judiciary. My Lord. My Lord, Honorable Justice Pedro.
The acting director trying to join. I've been trying to join. I'm using my other device. If you can allow us to come in, they keep bouncing us out. Can they allow us?
My Lord. Would,
yes, if they can allow us.
Yes, my Lord, they will allow.
Okay, all right. Okay. They've not yet allowed us.
Okay, my Lord, is this on another device?
Yes, please.
Okay.
So with that, you can actually, my video can be seen.
Okay.
Okay. Okay, let me. Okay, I'll just continue with what I have.
Thank you, my Lord.
Okay, can you hear me now? Can you hear me now?
Yes, my Lord, we can hear you.
Oh,
we can hear you louder. Thank you.
I'm trying to see whether I can start my video on this, but I think because of the sharing, it may be difficult. Okay. Now, my Lord, the Honorable Chief Judge of Lagos State, Honorable Justice Kazeem Olanrewaju Alogba, my Lord, the Honorable Admin Judges here present, my Lords, Honorable Judges of the High Court here present, Your Honors, members of the Governing Council, the Acting Director, Lagos Multi-Door Courthouse, our distinguished speakers for today, and our participants. Let me say that I consider it a privilege to be able to deliver this paper, which is Social Impact of Restorative Justice on the Society and the Role of the Judiciary. Now, I start my paper. Now, the increasing rate of crime and the high percentage of accused persons awaiting trial in custody are major concerns for the government in many nations of the world. And of course, Nigeria is not an exception. Earlier this year, it was reported that a total of 51,541 out of the 75,635 inmates, 68% in various prisons in the country are awaiting trial. It was further reported that those awaiting trial were not included in the rehabilitation exercises in the correctional centers, except for those who voluntarily chose. So the effect of this is the increased recidivism, which is reported to be higher among persons awaiting trial. And this is a threat to the economic development and security of the country. Now, in the year 2015, the Administration of Criminal Justice Act, ACJ, was reformed, and one of the major reform provisions established the restorative system of justice in Nigeria. The explanatory memorandum of the ACGA captures clearly the essence of restorative justice. It states that the Act provides for the administration of criminal justice system which promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crimes, and protection of the rights and interests of the suspect, the defendant, and victims in Nigeria. Sequel to this, and for the effective management of criminal cases suitable for restorative justice, the Lagos State Judiciary enacted the Practice Direction on Restorative Justice in the year 2019. It is expected that with the implementation of the restorative justice, minor offenses will be referred to relevant centers and restorative justice outcome applied to ensure that persons who commit minor offenses will no longer end up in prison, but in the alternative face non-custodial punishments, including fines, restitution, others, community service, others. What is restorative justice? Restorative justice refers to an approach to justice that seeks to repair harm by providing an opportunity for those harmed and those who take responsibility for the harm to communicate and address their needs in the aftermath of a crime. Simply put, restorative justice means restoring victims, offenders, and the community. It is germane to state that as opposed to what operates in the traditional criminal justice system, where the focus is majorly on the offender and not on the victims, the restorative justice process provides an opportunity for the victim, the offender, and other affected persons to address the underlying causes of a crime and generate solutions to many contemporary social problems by building and repairing social relations, generating mutual understanding between affected individuals or groups, and strengthening personal responsibility to respect the feelings, needs, and values of others. What are the principles of restorative justice? 1, crime is fundamentally a violation of people and interpersonal relationships. Basically, victims and the community have been harmed and are in need of restoration. The primary victims are those most directly affected by the offense, but others, such as family members of the victims and the offenders, witnesses and members of the affected community are also victims. The victims, offenders, and the affected communities are the key stakeholders in justice. A restorative justice process maximizes the input and the participation of these parties, but especially the primary victims, as well as the offenders, in the search for restoration, healing, responsibility, and future prevention. The roles of these parties in the restorative justice process will also vary according to the nature of the offense and the capacities, preferences of the parties. Number 2, violations create obligations and liabilities. Offenders' obligations are to make things right as much as possible. The primary obligation is to the victims. A restorative justice process empowers the victims to effectively participate in defining the obligations. Offenders are provided with the opportunities and the encouragement to understand the harm they have caused to the victims and the community at large, and to also develop plans for taking appropriate responsibility. Voluntary participation by offenders is also maximized, while coercion and exclusion are minimized. However, offenders may be required to accept their obligations if they do not do so voluntarily. B, the community's obligations are to the victim and to offenders, and for the general welfare of its members. The community has a responsibility to support and help victims of crime to meet their needs. The community also bears a responsibility for the welfare of its members and the social conditions which promote both crime and community peace. The community also has a responsibility to support efforts to integrate offenders into the community, to be actively involved in the definitions of offender obligations, and to ensure that there are opportunities for offenders to make amends. Number 3, restorative justice seeks to heal and put right the wrongs done. The needs of victims for information, validation, vindication, restitution, testimony, safety, and support, they are all the starting point for justice. It's important to know that the safety of victims is an immediate priority. The justice process provides a framework that promotes the work of recovery and healing that is ultimately the domain of the individual victim. Also, victims are empowered by maximizing their input and participation in determining their needs and outcome. And offenders also get to repair the harm created as much as possible. B, the restorative justice process also maximizes opportunity for the exchange of information, participation, dialogue, and mutual consent between victim and offender. Face-to-face encounters are appropriate in some instances, while alternate forms are more appropriate in others. Victims are also given a chance to define and direct terms and conditions of exchange. Mutual agreements are encouraged and opportunities are created for remorse, forgiveness, and reconciliation. C, offenders' needs and competencies are addressed. This allows for recognition of the fact that offenders themselves have often been harmed. Healing and the integration of offenders into the community are emphasized. Offenders are also treated respectfully in the justice process. Removal from the community is restricted to the barest minimum, and personal change is valued over compliant behavior. D, community members are actively involved in the restorative justice process. The process draws from community resources that in turn contributes to the strengthening of the community. It also promotes changes in such a way that similar harms are prevented and the needs of victims are addressed while demanding for accountability from offenders. E, the restorative justice process is also mindful of the outcomes intended and unintended of its responses to crime and victimization. It encourages and monitors follow-through since the healing, recovery, and accountability and change are maximized when agreements are kept. Fairness is also assured not by uniformity of outcomes, but through the provision of necessary support and opportunities to all parties and avoidance of discrimination based on ethnicity, class, and sex. Outcomes that are predominantly deterrent should be implemented as a last resort while seeking the restoration of all the parties involved. F, unintended consequences, such as co-optation of restorative processes for coercive or punitive ends, undue offender orientation, or the expansion of social control are resisted. Benefits of restorative justice. The benefits of restorative justice are numerous. There are benefits to the community, the victims, and the offender. One, benefits to the community. There is reduced recidivism. Restorative justice has a high rate of success in reducing repeated offenses. People who have offended have the opportunity to make things right, learn from the process and put the matter behind them so that they can more easily go on to live a crime-free life. Increased safety. That's B. When recidivism is reduced, we have a safer environment. Restorative justice empowers individuals to make their neighborhoods and towns more pleasant to live in. And C, cost effectiveness. The restorative justice process saves the state money by preventing individuals from becoming part of the criminal justice system for offenses that can be resolved at the local level with the participation of the community and the victim. 2, benefits to the victim. A, empowerment. When victims are offered the opportunity to have a safe and facilitated dialogue with the person who harmed them, they feel empowered and invested in the process, in the sense that victims need to acknowledge and considered, which gives them a voice in an open, impersonal system. B, meaningful dialogue. Victims are given opportunity to explain how they were harmed, get answers to their questions, and state what they need the offender to do to make amends. C, recovery and satisfaction. Restorative justice boasts a high rate of victim satisfaction. Many are able to recover what was taken from them, whether it be material possession or their sense of security and their peace of mind. They are more likely to be able to move on from the incident and get back to their daily life. That gives them closure. 3, benefits to people who offend. A, an opportunity to make it right. People who offend have the opportunity to express remorse and apologize for their actions, benefiting themselves as well as the victims. The incident behind them. People who offend have the opportunity to make significant and appropriate amends and then move on. They're able to return to their communities knowing that the matter is settled. C, a timely resolution. The process of restorative justice is swift in comparison to the criminal justice system so that offenders can move quickly and make meaningful changes in their lives. D, a high success rate. Restorative justice has a high rate of compliance or completion. Within a voluntary and non-coercive process, people who have offended tend to follow through on agreements that they have a part in creating. What is the role of the judiciary? The judiciary has a vital role to play in ensuring restorative justice gains awareness and acceptance within the justice system. Our justice system typically focuses on the victim and fashions a hostile relationship between the offender, the victim, and the community because of its retributive and punitive nature. With the enactment of the Practice Direction on Restorative Justice, the Honorable Chief Judge of Lagos State has set up Restorative Justice Center in some magistrate courts in Lagos State. Judges and magistrates are encouraged, where the law permits and where the justice of the case so allows. One, to refer cases that are suitable to these centers and community service units for settlement. Two, upon conviction, to use as much as possible non-custodial sentences, fines, restitution as provided, forfeiture, community service orders, which include environmental sanitation orders, assisting in the care of children and the elderly in government-approved homes, or any other type of service that will have a beneficial effect on the offender. Truly, restorative justice can be used to balance the justice system in Nigeria, which in turn will result in reducing offenders' imprisonment and prison overcrowding. It is important to state that not all cases are suitable for restorative justice under the practice direction, such as capital offenses, sexual offenses, kidnapping, domestic violence, and terrorism. In addition to the provisions of the practice direction relating to the promotion of restorative justice by magistrates and judges, the judiciary has a role in A, providing opportunity for victims, offenders, and the communities affected by a crime to communicate about the causes, circumstances, and impact of that crime and to address their relatedness. B, ensuring that there is a guided facilitation process that is accessible, compassionate, promotes the safety and reintegration of offenders into the society. C, monitoring and encouraging the follow-through of the process to ensure that agreements made are kept. D, ensuring fairness and avoiding discrimination based on ethnicity, class, and sex. And E, providing an avenue for restitution and reconciliation. Conclusion, the world is evolving and will continue to do so. Hence, in a very short time, restorative justice has grown from a relatively beginning ideology into a generative force that impacts the way we understand and respond to crime and conflict in diverse communities throughout the world. It is a time for us to rethink how certain criminal matters can be resolved via restorative justice rather than its normal retributive and punitive approach of dealing with an offender once is found guilty. By fully embracing the restorative justice process, we have the opportunity to build a far more accountable, understandable, and healing system of justice and law that can lead to a greater sense of community. Thank you for listening.
Thank you very much, my Lord, Honorable Justice J.O. Pedro, for that enlightening presentation. Thank you so very much. I hope we are taking notes, and then if we have questions, kindly remember to put them in the chat box, and there will be time where all the questions will be addressed. And please state kindly say the name of the person you want, the presenter you want to answer those questions as well. Thank you for your time. We move on to the next presenter, Mr. Moyosore Jubril Onigbanjo, SAN, Attorney General and Commissioner for Justice, Lagos State. Born in Lagos, Moyosore Onigbanjo, SAN, is a graduate of the Obafemi Awolowo University, Ile-Ife, where he received a Bachelor of Law degree in 1988. He was called to the Nigerian Bar in 1989. After his call to the Nigerian Bar in 1989, Moyosoro Onigbanjo SAN cut his legal teeth in the law firm of Akin Delano and Co. as managing associate and thereafter joined conferred him with the rank of senior advocate. It was until August of 2019, a prosecutor before the body of benchers Please join me in welcome Mr. Moyosoro Onigbanjo SAN, ably represented by Ms. Adetutu Oshinusi. She's the Directorate for Citizens' Rights, Lagos State Ministry of Justice. I should be taking us on the topic, the Restorative Justice Hub, Policies and Procedures. Thank you very much. You're welcome.
Yeah, good afternoon, all. Good afternoon, Honorable Honorable Chief Judge of Lagos State, Justice Alugba, and all the judges present on this program. I stand on existing protocol as well. Firstly, it is necessary for me to apologize the unavoidable absence of the Honorable Attorney General of the state, Mr. Moyo Sore Onigbanjo, SAN. I'm here to present his paper. I am Adetutu Oshinosi, Directorate for Citizens' Rights, Lagos State Ministry of Justice. Yes, here is the Honorable AG's presentation. Well, as earlier mentioned by Honorable Justice Pedro, she has excellently presented to us the fantastic clarification as to the concept of restorative justice. Well, in the Justice Ministry of Lagos State, we have a program which is called the Restorative Justice Center, which is in furtherance and fulfillment of the policy of the state as to the quick and free access to justice in the state. The program is actually under supervision of the Chief Judge's Reform Committee, which meets quarterly and reports activities to be forwarded to the Honorable Attorney General on a monthly basis. Well, in furtherance of the objective, a hub has been created for the restorative justice referrals. The center that is established was launched on the 29th May 2022 at the Ministry of Justice, and it actually became operative in June of 2022. Since its inception, the hub have actually treated over 50 cases, and the target of these cases are offenses varying from stealing, assault, malicious damage, breach of peace, and other minor offenses. Referrals have been received from the magistrate court, also the DPP's office, and this is at the stage of advisory. When the DPP is advising, they consider the nature of the offense that has been committed and advise adequately. If it's all these minor offenses, it is advised, or rather advised by the DPP, that the matter be referred to restorative justice. And to achieve high scores, several magistrates in the state judiciary have been trained in the implementation of the restorative justice. And this enables minor criminal cases to be resolved without full trial to the satisfaction of the parties involved, and the terms of agreement reached are made, the terms of agreement reached are made judgment of the court. Apart from the magistrates training, other volunteer mediators have also been trained to facilitate the restorative justice sessions. Also, in furtherance of the implementing the restorative justice program, given the critical role played by the Nigerian police as a first point of contact when a crime is reported, the center has partnership with the police and has designated some area commands across Lagos State as restorative justice facilitating units. And they are nominated police officers have been trained, and facilitators and what the work along with the other trained facilitators of the state. The designation of the area commands of the police are to further enhance the conflict resolution mechanism within the state and reduce the volume of minor offenses filed at the magistrate courts. This, in no doubt, discongets the dockets of the courts and the volume of cases being handled by the prosecutors. To further enhance and ensure adequate sensitization and mobilization of all stakeholders in the administration of criminal justice, the center established is set to commence sensitization at correctional facilities also across the state. Also, we have requested from the correctional centers a list of defendants and suspects awaiting trial or ongoing who are in custody and where cases fall within minor offenses or misdemeanor. This is to enable us work and sensitize these categories of inmates and where applicable, refer them for restorative justice. Well, right now, the center is functional, in full function, and we receive so many referees, so for which we have to consider the viability of these referees before before any of these facilitators is contacted to come and sit and mediate of the matter. So in short, the restorative justice system is more like a mediation, and all that is being taken and all the terms that are signed are also are referred to the court and made a judgment of a court. So that is actually the process in which the hub operates for now. Thank you very much. Hello. Hello.
Hello. Thank you very much, Mrs. Adetutu Oshinosi, for that very interesting presentation. Thank you for giving us a peek into the happenings at the Restorative Justice Hub. Right now, we would move on to the next speaker. That's Mrs. Achere Cole. Achere Cole holds a master's degree in public policy and management from the School of Oriental and African Studies, University of London, and a second master's degree in law from the University of Lagos. And she's a barrister and solicitor of the Supreme Court of Nigeria and is a CEDA UK accredited mediator. She's a fellow of the Chartered Institute of Arbitrators UK, as well as a fellow of the Institute of Management Consultants, FIMC. She's a trained restorative justice facilitator and practitioner. Achere has national and regional experience in building AJR mechanisms and capacity. She consulted for the Judiciary of Kenya and the International Development Law Organization on the project to support the implementation of the Sustaining Judiciary Transformation Blueprint of the Judiciary of Kenya, and was an external evaluator for a court-annexed pilot project that was commissioned by the Kenya Office of the IDLO and International Commission of Jurists, the Kenya Human Rights Commission, and the High Court of Kenya for the Family and Commercial Divisions of Milimani Law Courts in Nairobi, Kenya. She was part of the pioneer staff that midwifed the establishment of the Lagos Multi-Door Courthouse under the Negotiation and Conflict Management Group. She also provided training for mediators and staff of the Kaduna and Abia Multi-Door Courthouses under a World Bank assisted project to expand AJR institutions in Nigeria, and was part of the team that trained staff of the Kano Multi-Door Courthouse to enable the KMDC start operations under the Security, Justice and Growth Program of the British Council. Achere co-authored the first restorative justice training manual in Nigeria for the Rule of Law, Anti-Corruption ROLAC program of the British Council with the support of the European Union. She has provided intensive restorative justice training for over 300 RJ facilitators from the Lagos and Edo State Magistracy, Lagos and Citizens Mediation Center, Lagos State Ministry of Justice, and the Police Force. And in 2022 was faculty member for the United States National Institute for Trial Advocacy Capacity Building Program on Trial Advocacy, Ballistics, and Restorative Justice. She was head, Human Resources and Administration of Capital Partners Limited, and was Workforce Assessment Team Lead as part of a team of consultants responsible for the Bank PHB Retail Strategy Implementation Project, and is a trained election observer by the Kofi Annan International Peacekeeping and Training Center, Ghana. She was also a member of the Pioneer Governing Council of the Citizens Mediation Center, Lagos State, and was Deputy Director and Head of Operations at the Lmdc. Achere has vast experience in resolution of disputes through mediation and arbitration, design of case management and dispute resolution processes, development of sustainable public policies, development of curriculum for mediation skills training, mediation advocacy training, restorative justice training, and human resource policy review. She is a faculty on the Lmdc Mediation Skills Training Program and is a proficient and interventionist mediator in fields which cut across commercial contracts, family, criminal, and employment disputes. She's an active member of the Lagos State Restorative Justice Steering Committee and is now the acting director of the Lagos Multi-Door Courthouse. She's also secretary to the Governing Council of the Lagos Multi-Door Courthouse. Mrs. Achere Cole will be speaking to us on the Lmdc Restorative Justice Youth and Juvenile Reform Program. Thank you, Mrs. Cole.
Thank you, Mrs. Ojo. Good afternoon, everyone, and thank you for making our time to join this webinar. My Lord, Honorable Justice Alukwa, Honorable Chief Judge of Lagos State, please permit me to stand on all existing protocol. I would share my slide. I'm going to be talking about the Lagos Multi-Door Courthouse Restorative Justice Youth and Juveniles Reform Program, which my Lord had mentioned earlier, was launched during the 20th anniversary of the Lagos Multi-Door Courthouse, which held in June. And so this presentation really is going to be looking at the program, what it entails, and we're hoping that stakeholders here will find where to plug in and collaborate with the Lagos Multi-Door Courthouse. We've also run this program because we are aware that this is the International Restorative Justice Week for 2022, with the theme releasing the potential of restorative justice, available, accessible, and adaptable. And these are the words that the Restorative Justice Program of the Multi-Door Courthouse proposes to put forward using the program. Now we're going to look at just a general introduction on what we're doing here today, case referral to the Lagos Multi-Door Courthouse. We always use these webinars as an opportunity to talk about the Lagos Multi-Door and how you can refer your cases. Then we look at restorative justice, a bit of history and how we got here at Lagos Multi-Door Courthouse, SDGs, Lagos State themes, projects under this program, progress of the program, and of course, conclusion. Now, the Multi-Door Courthouse, the Lagos Multi-Door Courthouse is the first court-connected ADR center in Africa. It was established in 2002. It's interesting to know that it was through a public-private partnership with Lagos State Judiciary, giving sufficient support to the negotiation and conflict management group. What are the things that what are the doors when you hear multi-door? What are those doors that we use? We use mediation, arbitration, early neutral evaluation, hybrids. Hybrids mean a connection between mediation and arbitration. So you have MEDA or you can have arbitration and then move to mediation and back to arbitration. So those are the kind of hybrids we have. We also have now, of course, restorative justice, and we've resolved over 6,000 cases. The peculiarity of our kind of cases that we handle, they're quite large claims referred from the court and also referred from people working cases. So if you see, just in 2002, we have assisted in the recovery of claims in over 1 billion naira. We have a panel of neutrals of over 300 mediators, arbitrators, and RJ facilitators. And we have many objectives, but our key objectives are to enhance access to justice by providing alternative mechanisms for resolution of disputes. Now, restorative justice is one of these alternative mechanisms. Also, another key objective is the promotion of the growth and effective functioning of justice system through ADR methods in Lagos State, and we must say in Nigeria and in Africa, based on what we've been doing. Now, how do cases come to the Lagos multi-doc? How do you refer your matter here? So if you have a case in court currently, you can request for a referral, or the judge suo motu refers based on relevant provisions of the law, High Court of Lagos Civil Procedure rules. They can refer a case directly to the multi-doc courthouse. Also, you can walk directly in. And right now, I'm just seeing a chat coming in and say, we have a case, what do we do? So just know that you can walk in, you can go to our website and look at the processes there on how you can send your cases from anywhere actually in the world, because we use online dispute resolution. So you don't even have to walk in physically. So when we say walk in, just walk into our website, walk into our DMs, walk into our platforms, and we'll take up your cases. We'll be sharing at the end of the day whatever platforms we have. So please note those platforms when we share those platforms and numbers so that you can reach out to us. Another way you can bring cases come into the multi-doc courthouse is through direct intervention. So you see in the previous two cases, you have the court referring or you have yourself walking in. But in this direct intervention, we find out in the community, in society, in the nation, we look into cases that we feel we should intervene in, which are intractable, probably have gone on for a while, and we feel we have the expertise on our panel, and then we invite the parties, disputing parties, to the multi-doc courthouse for a resolution. So that's where you have direct intervention. And then also we have ADR track cases. So now the first one is court-referred cases. This last one is, these are cases that are screened under Order 5 Rule 8 of the High Court of Lagos Civil Procedure rules. It makes provision for such cases to be referred through, or once you bring in your originating summons, they are screened for suitability to ADR. So if you walk into the High Court, your case gets screened and is determined if it should go to the trial track or the ADR track. So that's what we call ADR track cases. Now, let's look at restorative justice at the Lagos multi-doc courthouse. What has the history been? Now, the Honorable Chief Judge of Lagos State enacted the practice direction on restorative justice in 2019. And then by 2020, December, we got an approval to start off our restorative justice unit. Just to give you a bit of background. Now, after that restorative justice unit was set up, about 11 cases were referred, 4 were resolved, 3 unresolved, 2 no-shows. What would be my no-shows is that people just didn't turn up. 1 wasn't suitable. At that time, we were of the opinion that parties must plead guilty, and the party refused, the defendant refused to plead guilty. So the case just didn't come in and wasn't suitable. And then in one instance, the complainant refused to meet with the defendant. So just to give you a sense of what happened earlier on in 2020, based on referrals that we got, types of cases that we dealt with at the time were stealing, breach of peace, threat, and nuisance. So these are the type of cases we saw in 2020 into 2021, really, 2021. And subsequently, upon our 20th anniversary in June, we then determined that it was important to use this restorative justice as a tool to reform youths and juveniles, not just in Lagos State, just as a general reformatory process. So that's the essence of Lagos multi-doc courthouse restorative justice youth and juvenile reform program. The Honorable Chief Judge has said it's quite a mouthful, but we'll see what we can do about the name. But right now it's RJ, Restorative Justice Youth, RJY, Juvenile Reform Program, JRP. So that's what the program is. So we premised this program on the SDGs 16, United Nations Sustainable Development Goal 16, which, and where we premised it within that particular SDG 16 is the significant reduction of incidences of violence in communities. We feel restorative justice is a tool to do this. And also, of course, to promote the rule of law at national and international levels and ensure equal access to justice. Remember, this is part of our objectives as an institution. In addition, under the Lagos State themes agenda, particularly security and governance pillar, we feel the restorative justice program would help in improving security under the Lagos State themes agenda. Just to give you more background on the program and where it is situated under the SDGs and the Lagos State themes agenda. Now, let's look at the projects of the program. So when we talk about the Restorative Justice Youths and Juveniles Reform Program, what are those projects we're talking about? The first one is that is the Lmdc Restorative Justice Community Center. So that community center is going to be located in various communities. First of all, starting out in Lagos State and of course across the nation. If other states need help, we're willing to help you out in setting up, these community centers. And then we have the Juvenile Reform Project, which primarily focus on correctional centers. So we'll be working, of course, you've heard Mrs. Oshinusi, who's representing the Honorable Attorney General, talk about the correctional centers. We're going to be working with the hub. We feel we'll have a place, and particularly we're focusing on juveniles in correctional centers or juvenile detention centers, rather. Now, the Restorative Justice Schools Project is another germane project dear to our hearts, because we find out that within the school system, the restorative justice values can be used to resolve disputes within the school system, and it will transform, of course, the youths within secondary school. So primarily, we're starting with secondary schools, and then finally, we are looking at a project on restoration and mental wellness. So we call it the Lmdc Restoration and Mental Wellness Center. So while you might see the word center might not particularly be a place. It might be a place, but it's also a philosophy that we feel is important to put into this package for youths and juveniles. So these are the projects we're looking at. Let's go and see the aims of each of the projects. The center, community center, is looking at transforming youths and juveniles within communities. Juveniles Reform Program is looking at reforming and reintegrating juvenile delinquents currently serving prison terms at juvenile correctional centers. Restorative justice in schools wants to empower students. So we're looking at empowering the students to air their grievances and resolve conflicts on their own in peer-mediated small groups and under the supervision of trained restorative justice facilitators. So it will be a train-the-trainer at the beginning. Eventually, we'll pull out, but at the beginning, we'll train the house masters, the teachers, the principals, and all of that, so that everybody gets a clear understanding of the restorative justice principles and how to use them. Of course, train the students too, and how to use them even in their small groups. And then, of course, the Restoration and Mental Wellness Center is a safe place where juveniles and youth will be prepared for reintegration into society. We believe that reoffending or even crime is as a result sometimes of some form of mental unwellness. So we need to plug that gap, and we're going to be leaning on the relevant professionals. So we've already reached out to psychiatrists and clinical psychologists to tell us what they have learned in this area. Is there a nexus? And also not just for the offender, of course, also for the victim. Victims of crime also need a lot of healing. So these are the key programs we're looking at. Those are the aims of those programs. So let's look at, this is hanging a bit. Busola, can you still hear me? Hello, Busola? You can hear me? Okay, that's fine. Okay, so those are the aims of the various projects. And let's look at deployment. So you see this, we're engaging stakeholders across board. There are tons of stakeholders across the criminal justice sector. We're going to be engaging them through webinars, through direct visitations, a lot of awareness creation, identification of suitable locations, for the community centers within particular local government areas. We're going to be doing pilot projects to start out. And then, of course, training and capacity building is going to take a lot of training and capacity building because restorative justice is new, maybe not in philosophy, but in terms of process. And then, of course, recruitment and volunteering. We're going to be leaning on people. We're going to have to recruit. And of course, we're going to need a lot of volunteers. Then case identification, and of course, monitoring and evaluation of the program. Work in progress. Where we are now, since June, at least we can say, and we thank the Lagos Island West local government and Mushin local government for giving us permission to establish a restorative justice community center within these two local governments. These are our first project, pilot projects. Let's see how it works before we scale it up into other local government areas. So we're working on building the necessary infrastructure in those two local governments, not a big building, but at least infrastructure will be created. Awareness creation, we're going to begin to run seminars within the various local governments. We have published a restorative justice brochure, it's a mini brochure, but at least it's a guide to all our projects. And of course, we've commenced collaboration and we're beginning to seek for sponsorship. And we're reaching out to see as much sponsorship as we can get because we believe that this program is a really transformatory program for the society. So that in a nutshell is the Restorative Justice Youth and Juveniles Reform Program, RJYJRP. That is the program. And we hope with this program, even in accordance with the theme of this Restorative Justice Week for 2022, we will make restorative justice available, accessible, and adaptable to the communities, to the prisons, to the schools. And of course, it will promote a lot more mental wellness and ultimately result in a violent-free community at the end of the day. So thank you very much, Ms. Sojo. I'm done.
Thank you very much, Mrs. Cole. Thank you for that wonderful presentation. And I'm sure we're learning a lot from your presentation. Just before we move on to the next speaker, I would like to state, apologize for the poor audio earlier, and we're sorry about that, but I'm sure we can hear us loud and clear now. And we'll move on to the next speaker.
Dr. Bello, please.
That's Dr. Akim Olajide Bello. Dr. Akim Olajide Bello. Dr. Bello is an associate professor at the Department of Public Law, Faculty of Law, University of Lagos. He's an expert in criminal law and criminal justice. He served as senior special assistant on public and constitutional law to the governor of Lagos State between 2007 and 2011. He served as a law reform commissioner with the Lagos State Law Reform Commission between 2012 and 2015. The commission compiled and published the laws of Lagos State 2015. He has published learned articles in local and international journals. He's the co-author of Ministering Justice, the Administration of the Justice Sector with Olasupo Shashore, SAN, and author of Overview of Plea Bargaining in Nigeria. He has consulted for British Council, Foster, UNODC, GIZ on justice sector, plea bargaining, and restorative justice. We welcome Dr. Akim Olajide Bello to take us on the topic, the value of restorative justice to the criminal justice system, looking at restorative justice in schools, correctional centers, MBA, and the police. Dr. Bello, please.
Thank you very much for having me. And I want to thank Mrs. Cole for the invitation to be part of this event. I appreciate your invitation, and I will spend a couple of minutes to look at the value of restorative justice to the criminal justice system. The presentation examines the value of restorative justice to the criminal justice system. That's the first part. While the second part examines the role of the following stakeholders in relation to the value of restorative justice. I will, of course, in the presentation of my Lord Honorable Justice Pedro, she had laid the foundation for the concept of restorative justice, which is an approach to justice that seeks to repair the harm involved in an offense that has been committed, and through a meaningful dialogue between the offender and the victim to find means of addressing the impact of the harm on the victim. And this is in contradistinction to the traditional criminal justice system, the principal focus of which is to determine guilt of the offender and to punish the offender. Now, the first part of the presentation deals with the benefit of restorative justice. And this has been adequately covered by the presentation of my Lord Honorable Justice Pedro. So we can just quickly see the highlight of the benefits there. It reduces recidivism, increases safety, leads to cost effectiveness. It empowers the victim to have a voice. It creates opportunity for meaningful dialogue. It creates opportunity for recovery and satisfaction and a timely resolution of disputes. So I will not spend much time on that. I would rather go on to the other aspects of my presentation. Now, we will look at some stakeholders and then we'll be able to see their role in being able to achieve these benefits of restorative justice. The first is the school system, restorative justice in school system. I mean, it's very exciting to hear Mrs. Cole that the Lagos Multi-Door Courthouse wants to take restorative justice to schools. In fact, there's a body of research that indicates that a restorative justice approach to handling violation of school rules has tremendous positive advantages in improving the school environment and in the development of the youth. So there's a body of research that has clearly demonstrated the benefits of adopting restorative justice to deal with issues of violation of school rules and disciplinary issues within the school environment. And this body of research, I mean, spans from United Kingdom all the way to United States. These are researches that have been conducted that has demonstrated the efficacy of restorative justice in improving the school environment and the development of young adults when they are exposed to restorative justice processes in resolving issues of school violation. I mean, we know that the typical outcome when you violate the school rules is that you are sanctioned. Either, depending on the gravity of the rule that has been violated, it could be a suspension or some other forms of disqualification. But in schools that have adopted the use of restorative justice practices and processes, there is evidence to show that it has tremendous positive advantages. And it's very gladdening to hear that the Lagos Multi-Door Courthouse is about embarking on this project to bring restorative justice into the school environment so that school authorities can begin to utilize it and they can begin to reap from the positive advantages that follows the use of restorative justice. So I have a couple of recommendations there that may serve Lmdc well in their endeavor to utilize restorative justice in dealing with issues of violation of school rules and disciplinary issues within the school setting. One is that they have to offer professional development in restorative justice philosophy and practices to all staff in the school environment, including even those who are non-teaching staff. So there has to be a process of developing the capacity of staff in these schools to understand the philosophy of restorative justice, to understand the values of restorative justice, and then be able to deploy it. And then, as you embark on this laudable venture, it's also important that you need to develop and maintain a cohort of highly skilled facilitators. I know you have some of your mediators who have already been trained in restorative justice. so they have the skills, they have the capacity and the competence to administer restorative justice. So you can use them as part of the process, even as part of the process of developing the capacity of staffs of this school. And schools must be encouraged to use restorative processes to deal with incidents of inappropriate behavior in their school. And there's also the need to support restorative justice philosophy and practice through teacher education. The training of teachers must now include training in restorative justice, so that because usually the training of teachers includes how to deal with issues of school violation of school rules and disciplinary issues. So now that the restorative justice is going to be brought on board, so there's a need for teacher education to now include modules on restorative justice. And of course, you also, Mrs. Cole also made allusion to this. There may be a need to try out pilot programs so that you can try out the program, make mistakes and learn lessons, and then be able to replicate as you take it across the school. So I can imagine that you're going to start with a couple of schools, and then as you deploy it and as you learn lessons, you'll be able to replicate it across the entire school system. Then there's also the role of correctional centers in restorative justice. The recent Nigerian Correctional Services Act of 2019 has now established the Nigerian Non-Custodial Service and saddled this with responsibility to oversee the implementation of non-custodial sentences and restorative justice. So the responsibility of the hitherto Nigerian prison service has now been expanded to embrace correctional service, and in particular, the implementation of non-custodial sentences and restorative justice. And the Act requires the Controller of Corrections to provide a platform for restorative justice measures, offender mediation, family group conferences, community mediation, and other measures. So what that means now is that the correctional service must of necessity develop the capacity to be able to implement non-custodial sentences and to be able to implement restorative justice, I mean, in all its facets, so that all the advantages and the positive benefits in restorative justice can begin to come to our correctional system. I also have a couple of suggestions which will assist the Nigerian Correctional Service to discharge this statutory mandate. The first is that they need to draw up an action plan to implement the provisions of the law. You know, frequently in Nigeria, we reform laws, we enact new laws, but we don't take the pains to do the costing of what it will take to implement the law, and then to have a plan of implementation in place. So I think this is very critical. This is a new area for the correctional service. So they need to sit down. What will it cost us to train our officers? What are the resources that will be required? How much of those resources can we have access to over a period of time? And then they need to be able to draw up an action plan to implement the provisions of the law, so that within the first 5 years, we know what they are doing. The next additional 5 years, we know the next phase. The next 15 years, we know they are doing it. And then they'll be able to also explore various funding opportunities. And this is also very significant. The service should collaborate with states already implementing non-custodial measures and restorative justice initiative. Lagos is one state that is already implementing non-custodial measures and restorative justice. And I know that there's a lot of collaboration between the correctional services and the Ministry of Justice and the judiciary. In fact, the Nigerian Correctional Service has a representative on the state's restorative justice implementation committee. So that is good. So across the states where we have the Nigerian Correctional Service, they need to collaborate with states that are already involved in implementing restorative justice in one form or the other. Across the states, we have ministries or Department of Social Welfare who are usually in charge of young offenders, the supervision of young offenders. They will have some experience in this area. So it's important that the correctional service collaborate with relevant state agencies in that regard. Now, the Nigerian Bar Association. Of course, we know that the Nigerian Bar Association plays a very critical role in the implementation of criminal justice, particularly the role of individual defense counsel. And we know that the curriculum at the law school prior to this time does not involve some of the new areas of justice that are emerging. For instance, plea bargaining, non-custodial sentences, restorative justice. So there is a need for defense counsel's capacity and capability in these areas to be developed and to be built. Defense lawyers need to know that they have a role to play in the implementation of restorative justice. Where a matter is referred to a restorative justice facilitator to resolve to restorative justice, defense counsels are not going to be shut out of it. They have a role to play. They have a right to attend such facilitation and, ensure that the rights of their clients are adequately protected. So there's a need for the Nigerian Bar Association to include modules on restorative justice as part of the continuing legal education development. And the NBA also needs to organize workshops and seminars on restorative justice for defense counsel. And in this regard, the NBA can collaborate with various donor agencies who are already very active in this field. For instance, the Rule of Law and Anti-Corruption Program of the British Council and European Union is very active in this regard. They've organized restorative justice training for judges, for magistrates, for defense counsels, for mediators, and so on and so forth. So the NBA can partner with these donor agencies, to organize workshops and seminars to further enlighten and build the capacity of defense counsels to be able to play their role in the process of using restorative justice. And of course, the Nigerian police is very critical in criminal justice administration, and they are very critical in restorative justice, particularly the initial phase of restorative justice, which as we're practicing in Lagos, the focus now is to try and divert minor offenses, minor charges that are not aggravated to restorative justice as a way of reducing the docket of the criminal court, as a way of reducing the long list of offenders who are on their waiting trial list. So the police is very critical. And as a matter of fact, the police is already playing a critical role in this regard. We all know that the police resolve minor cases between willing victims and defendants. Minor cases of stealing, minor cases of assault, minor cases of malicious damage to property. Once the defendant is willing and the victim is willing that the matter should be settled, the police have been in a position, to facilitate many of such cases. And many of these cases are actually resolved pre-charge. And that is one of the goals of the restorative justice program in Lagos, to ensure that minor cases, minor charges don't end up being charged in court. And that's why the judiciary has also adopted, a restorative justice practice direction. That's why the Ministry of Justice has set up the Restorative Justice Hub. And that's why effort is being made to ensure that those minor cases are referred to restorative justice facilitation. And where they are successfully resolved, then the parties are the facilitator will draw up an agreement which will now be filed in court, and the court can enter it as a judgment of the court. And again, in this area also, we've seen a lot of activities by the British Council through its rule of law and anti-corruption program, which has trained 25 middle-level police officers in 5 divisional police offices in Lagos on restorative justice. Of course, this training needs to continue, to expand across all police divisional offices in Lagos, and indeed to all police officers. And in addition to that, it's also important now to ensure that there is a module on restorative justice incorporated into the training curriculum of the Nigerian police. I mean, if you go to the police academy now, they have their own training curriculum. And I know that in the last few years, the rule of law and anti-corruption program of the British Council has also assisted the Nigerian police to improve on that curriculum. So I assume and I hope that there will be modules on restorative justice already part of that revised training curriculum. And if it is not, then it's something that should be incorporated into it so that it will be part and parcel of the training of the police. So that as soon as they are in the police college and they are going through their basic trainings, they will have received trainings on what they need to do to facilitate restorative justice. So these are the various roles that some of these agencies can play in ensuring that we have all the benefits that I listed at the beginning on the benefits of restorative justice that I listed at the beginning, reduce recidivism, giving voice to the victim, reduction of costs, and so on and so forth. So I thank you for listening, and I hope that if there are questions, there will be opportunities to respond today. Thank you very much.
Thank you very much, Dr. Bello.
Thank you.
Thank you very much, Dr. Bello, for your presentation. It was very enlightening and informative. Thank you so much. Just before we move to the next speaker, we have a lot of questions concerning soft copies of the presentation. Please note that the soft copies of the presentations will be sent to participants after the webinar. I'll move on to Tim Chapman. Professor Tim Chapman had a lengthy career in the probation service in Northern Ireland, rising to a senior management position, Assistant Chief Probation Officer. He spent 10 years as lecturer and course director of the master's program in restorative practices at the University of Ulster. He now teaches at the University of Sassari, Italy, as a visiting professor, and at the University of Strathclyde as a visiting professor. He also offers training, research, and consultancy in restorative justice. He has published widely in effective probation practice and restorative justice. He's currently conducting research into victims' experience of restorative justice. Join me as I welcome Professor Tim Chapman as he presents his paper on setting up restorative justice institutions, perspective from another jurisdiction. Professor Chapman, please.
Thank you very much for that very kind introduction. I wonder, could my PowerPoint presentation be put on the screen?
Yeah. Dr. Bello, kindly stop sharing so that Professor Tim can begin his presentation, please. Thank you. Dr. Bello? Dr. Bello, can you hear me? Dr. Bello, if you can hear me, kindly stop share. Can you stop sharing your screen? Okay. Thank you.
Okay, let me. Oh dear, where is it? Sorry, this will just take 1 minute for me to find my presentation.
All right.
I'm sorry about this. Oh, I know. Sorry, let me just try again. Okay. Okay, sorry for that delay. Those of you who have heard me speak before will know I have a great affection for the country of Nigeria. I spent many years as a child growing up in your country, and I'm always very honored and very pleased to support your endeavors in any way, particularly in relation to restorative justice, which is very close to my heart. And in preparing this presentation, I gave it a lot of thought on what would be most useful for me to speak about in terms of the effectiveness of restorative justice in different contexts, community, schools, and prisons. So I've concluded that I will basically tell you the story of my own engagement with restorative justice in my own country, which is Northern Ireland, many thousands of miles away, and share with you what I've learned over those years, and mainly learned from my mistakes. So I'm sharing my mistakes so that you may be spared making my mistakes yourselves. So let me continue. So what is my key message today? I think I want to focus on the importance of context, the critical importance if we wish to be effective in delivering high quality restorative justice that yields very positive outcomes for our citizens and our population, that we need to understand the context in which we are delivering them, and to understand that no one size fits all. No one approach to restorative justice works in every context. A lot of what I have to say is reflected by my reading many years ago of a book, The Reflective Practitioner, How Professionals Think in Action, written by Donald Schoen, who's a theorist in organizational theory and learning theory. And I came across this strange phrase that I puzzled over for many years. He recommended that professionals should have a reflective conversation with the materials of the situation. I thought, how do you have a conversation with materials in a situation? And then slowly, as I learned from my mistakes, I began to understand what that meant. And I want to try and elucidate on that with you today. So my journey started with a reform of the youth justice system in Northern Ireland. In 2002, a law was passed stating that every young person under the age of 18 who admitted to an offence would be offered the opportunity to meet their victims. And this was not at the discretion of the judge, not at the discretion of the prosecutor or the social worker or the psychologist, but the judge or prosecutor had to say to the young person, we must offer you an opportunity to meet your victim. Would you be willing to do that? Over 90% of cases, they said yes. So this was a fairly radical law. I was at Ulster University at the time, and myself and colleagues were asked to design the program, design the process that should be followed. So we looked at the research. We had the benefit of having about 6 months to do this. We looked at the research internationally and considered how we might design an effective program. And the first thing we considered was the context in which young people who offend and their victims live in my country of Northern Ireland. And we concluded that you could not see a young person in trouble in isolation as an individual, that they're intimately bound up in their family and the experiences that they've had within their family, within their schools, and within their own neighborhoods and communities. So we had to think of a process that involved, that went beyond the individual and brought in people that the young person might be connected with. As I said, we had fairly radical legislation. Now, that meant that anything we designed had to be adaptable to any offense, from the most serious to the most trivial, any type of young offender, and any type of victim. So it had to be a very flexible and adaptable approach, not a rigid, prescribed approach. And there were, it had to include a diversity of victims and offenders. So we set about designing the program. And this is the second aspect that I want to talk about, the importance of designing according to the context and purpose of what you're doing. We wanted a holistic participation. In other words, that not just the young person and their victim would be present, as in a classic mediation, but their family, maybe representatives of the school, maybe representatives of the community would also be, and would also be participating. And also the victim would be able to bring friends or relatives to the meeting. We wanted a high victim participation. When we looked at the research, we found two contradictory messages. One, that restorative justice is much more effective if there is a face-to-face meeting between the perpetrator and the victim. Two, in most systems, there is very low levels of victim participation. So we wanted to sort of address this contradiction in practice. And we needed it to be inclusive and flexible because of the diversity of people that it would need to accommodate. Looking then at the process that we designed, we wanted a balance model. We called it the balance model of restorative justice. And that meant it needed to balance the needs and interests of the victim of the harm, the perpetrator of the harm, and the community in which the offense or the harm took place. We wanted to be inclusive and motivational. So we thought a lot about the skills that would be necessary to engage the victim. Not so much a problem with the offender because they're already in trouble and they're looking for a way out of trouble. But for a victim, why should I want to meet somebody who's harmed me? And we developed, I think, an effective approach, which was basically saying, we're not inviting you for the benefit of the offender. We're inviting you for the benefit of yourself. What do you think might be the benefits for you to participate in this? And then we devised what we called a restorative conference model, which is not a sort of mediation model. It's more of bringing all the stakeholders to harm together and entering into dialogue until there's a common understanding and an agreement on what needs to be done. The outcomes were excellent. We did get a high level of participation of victims and a high level of satisfaction of all parties. They enjoyed the process. They thought it was meaningful and effective. It reduced offending. I was a probation officer for many years, and our offending rate was about 50%. In restorative justice, and bear in mind, we're dealing with prolific offenders, serious offenders, as well as low-level offenders. The reoffending rate was around 30%. So we made a profit there. And surprisingly, and this is something we didn't recognize at the first, it reduced the level of custody. My speculation, and I haven't researched this, is that this was because judges were getting reports from victims of the conference, and victims were very positive. And so judges didn't feel under pressure to punish severely because they'd listened to the victim and they'd said, we've met the offender, he has apologized, he's shown remorse, he's willing to do this to repair the damage, we are satisfied. And judges quite often said, well, if you're satisfied, then I'm satisfied. And so our custody level went down dramatically. Moving on to community. So you can imagine, after having that success in youth justice, I thought, I'm pretty good at this. And all I have to do now is, use what I've learned from youth justice in other contexts. The other area in Northern Ireland that was very interesting was a lot of community groups, a lot of neighborhoods wanted to have local community restorative justice projects. This is developed, and some of you may be aware of this. We had about 30 years of very violent political conflict during the 60s, 70s, and into the 90s. And during that time, there was a lot of crime, and the police and the criminal justice system could not work effectively given the threat of terrorism. So local organizations started to engage in trying to prevent crime and deal with offenders. And they chose, to cut a long and complicated story, they chose restorative justice. So we were asked to train the community activists. Again, we looked at the context. Coming out of a culture of violence, a lot of people had spent 30 years thinking violence is the answer to every problem. And we wanted to help them see that non-violent conflict resolution, restorative justice could be much more effective. There was a great distrust of the police and the criminal justice system in general, so that we needed to take that into consideration. And we lived in a polarized community. We had two large communities that didn't get on with each other, and were often quite violent and aggressive towards each other. So the design factors, we encouraged local offices and local workers, people from the community, to be trained rather than middle-class professionals coming into deprived communities. They had a pragmatic rather than an academic approach. It wasn't a carefully research-based design. It was much more the pragmatics of living in a community that had suffered violence and were suffering a lot of deprivation. And local people wanted a rapid response. If they didn't see a rapid response to their problem, they would turn to violence. And there were people in the community who were willing to inflict violence. So the process was very much influenced by a community development approach, bringing the community with you, empowering the community, outreach to youth from a preventative point of view, not waiting till they got into trouble, but trying to prevent. And also it was basically a community mediation model. So whereas in the formal system, we used a conference model, it was much more appropriate to use a community mediation model, because in the community, they don't have a system, the criminal justice system, that tells them this person is an offender, this person is a victim. It's much more complex. There's a longer history, to problems between families and neighbors and local youth and older people. So it wasn't as simple as saying, you're the victim, you're the offender, now let's mediate. So a much more fluid situation. Outcomes, these projects quickly gained community credibility, mainly because they were based in the communities, they were staffed by people that were known on the street, and they were pragmatic and quick in their response to problems. Crime reduced in those communities, and there was less violence. Violence was reduced markedly as a solution to problems. Moving on to schools, we were then asked to provide a training program to about 10 schools in Ireland who wanted to become restorative schools. So we had to look at the context again. The first thing that we noticed was time. I thought teachers would have a lot of time because they're spending all day with pupils. But they said in modern teaching, the timetable is very tight. We have homework, we have a lot of administration. We don't have time to plan and prepare for conferences or even mediations. So that made us have to think about how do we change our approach. A lot of schools had a punitive and exclusionary culture. In other words, they used punishment to exclude children that were causing problems, expelling them or suspending them temporarily. And there was an inconsistency of discipline. I'm an old man, but I can remember being at school. There were some teachers that were soft, some teachers who were hard, and some teachers you really liked, and it didn't matter if they were hard or soft, you would still behave well because you liked them and they showed care and concern towards you. So inconsistency was a problem in these schools. So what were the design factors? We needed to design brief interventions. Teachers did not have time. They're not social workers, they're not psychologists, they're busy people. Their primary function is to teach, and they don't have a lot of time to sit and talk to students, much as they might like to. that we needed to focus on building relationships rather than managing behavior. The previous way of dealing with it was to have a behavior policy. It was need to change that towards having a good relationship policy. And staff needed clear expectations, you know, from their managers about what is expected of them in order to be restorative in their approach to education and relationship with students. The process we developed, corridor conversations. We asked teachers, how long do you have for a conversation if you need to address a problem? They were saying maybe 2 minutes. So we had to design a conversation they could have in a busy corridor for 2 minutes. Classroom circles, integrate the restorative practices within the classroom, within the routines of teaching. So to run circles within the classroom where issues would be discussed, sometimes problematic issues, but sometimes positive things like, what did you do at the weekend? Or what are you looking forward to at Christmas? You know, positive, enjoyable conversations, all about building relationships. And an emphasis on pastoral care, understanding when, you know, something's going wrong at home for a child, and that may be affecting their behavior, and to take that into consideration. The outcomes, markedly improved relationships. Our philosophy was, if students and staff are coming into school happy, they're more likely to learn, rather than unhappy and stressed out and exhausted and bullied. So improved relations created an improved learning environment. One school that we worked in could show that the exam results improved right from the start of the restorative experiment. And less exclusions, less kids being told to go home, being out of school, getting bored, getting into more trouble in their communities. So that was how we worked at schools. And the next area that I've been asked to talk about is prisons. And again, the prison service in Northern Ireland heard about this and asked us to talk to them about how they could develop a restorative approach to prisons. Their problems were discipline problems, prisoners breaking the rules. They also had a lot of conflict between inmates and staffing issues. Staff were moved about, they couldn't develop relationships with prisoners. They could be moved to another prison because there was always staffing problems within the prison service. So in design, we had to think, right, we need to make it project oriented rather than just teach people a method like mediation or circles. We also heard that the biggest inmate conflict was between what were called within our prison service enemies. These are prisoners who are asked when they get in, do you have any enemies here? And they might say, yes, I belong to a gang and there are members of the opposite gang in this prison. Or it may be a political thing. We have different politics or different religion, or it could be family feuds, could be a range of things, or just people who have a grudge. Now, this causes problem for a prison logistically, because if they're enemies, they're a security risk because they could kill each other if they met. So that means they can't go to visits at the same time. They can't go to education at the same time. They can't play sport at the same time. They can't go to rehabilitation programs at the same time. It's a logistical mess. So that was something we had to take into consideration. And also the sense that a prison is not just a secure place for locking up criminals. It's a community. People live in close proximity for a period of time. And we thought that's an opportunity for people to learn how to live in community if they're not being particularly successful at it when they're outside. So the process was mediation for the enemies. I observed one of these. One prisoner had accused the other prisoner of being part of a gang who tried to kill his mother. And I observed how they spoke about it and came to some sort of an agreement over it. And it was very successful. There were 150 enemies in this prison, and they had reduced them by 50 within the first few months. And they're still working at that. They set up a restorative landing, which meant that every week, the staff and the prisoners sat in a circle and discussed the problems that the landing was experiencing. and talked about the future, talked about the past, talked about how they could help each other. And so restorative circles and mediation were the key processes that they needed. Outcomes, there was a reduction in enemies that made life a lot easier in the prison. There were less discipline problems on the landings, and staff got greater satisfaction from the job. I remember visiting the landing where they were working, and this very tough, old-fashioned prison officer came up to me and said, "This is great. I used to come in to work wondering who I was going to have to fight. Was I going to get injured? Was I going to get hurt? Now I come in thinking, I must have a chat with that prisoner because he's always a little depressed after he has a visit with his family and he might be in a bad way. I'll go and have a private chat with him." He said, "I'm so much more satisfied with the work I'm doing. This is why I became a prison officer, not to lock people up, but to help them rehabilitate." So I just want to conclude with the lessons that I've learned. One thing that works in one context will not necessarily work in another context. So you really need to understand the context in which you're practicing. And that means, I think, be led by the values and principles and philosophy of restorative justice rather than just the methods. I know mediation is very strong in Nigeria and done very professionally, but don't just depend on one method. Don't put into the public's mind that restorative justice is mediation. Restorative justice can be a lot of things, including mediation, as you've seen. Design is important. Sit down and think, what is the best design of a process in the context that we're working and given our values and principles? And in terms of outcomes, continuously review the practice, the results, evaluate, and continuously improve. This is what we've tried to do in Northern Ireland, and I must say in my other work throughout Europe. And it pays off in the long term. It takes a while, but it pays off. Thank you very much for your attention.
Thank you very much for sharing with us your wealth of experience. Thank you so much. Now we're going to be launching the second poll. That will take about a minute. Kindly respond within 1 minute of the poll. Right now, we would move straight to the question and answer session. And I'll be reading out some questions posted by participants at the group chat. This question will be directed to Dr. Bello. It says, why is restorative justice restricted to certain criminal cases? Is there any possibility in capital or sexual offenses? Dr. Bello, please.
Thank you very much. I believe you can hear me.
Yes, we can.
Okay. Restorative justice can take place in relation to any offense, and it can take place at any stage of the criminal justice process. So the restriction of, well, I will not say restriction, the limitation of restorative justice at the moment to minor offenses is just a matter of choice. Matter of choice because we are just adopting the process. People don't, a lot of members of the public don't understand what it is all about. So it's like going at it one at a time until we all begin to see the values of restorative justice. And a better case can be made to extend it to all the phases of the criminal justice process. And also, why it is being limited to now to minor offenses is because those minor offenses are more readily amenable to resolution, because the harm involved in them is not as much as the harm involved in minor cases of stealing, minor cases of assault, minor cases of malicious damage to property. It's not the same as the harm involved in rape, in armed robbery, in murder, in manslaughter. So it's just question of deliberate choice. In fact, we are already working on the restorative justice draft bill, and recognizing that it can be at any stage of the criminal justice system. It can be used even for very serious offenses after conviction. I mean, after trial and conviction. So it's not that conceptually it must be limited to minor offenses. It's just a matter of choice for
now. Okay, thank you very much, Dr. Bello. I believe that question has been answered. We'll quickly run through the next set of questions. This is from Dr. Agbelusi. It says, my submission is simply that restorative justice between victim and offenders should be after conviction. Otherwise, most valuable time is spent working on the offender who is still claiming innocence of the charges. What are your thoughts? I believe that should be for Dr. Bello, please.
I don't necessarily agree with you. Sometimes the process of resolve of restorative justice may take time. But don't forget that part of the precondition is that before the process starts, the offender must be willing to admit responsibility. So you are not bringing an offender who is coming to claim his innocence or to justify his action to the restorative justice table. Okay, so once that important precondition has been fulfilled, then the task of or the possibility of being able to resolve the matter becomes higher because the offender is already, and don't forget, even at this level, the parties, the facilitators try to explain to the offender the benefit of the restorative justice to the offender. Because if the offender is able to go through the process and the matter is resolved, the matter may never be filed in, no charge may ever be filed against him in relation to that minor offense. So there are incentives for the offender to be willing to participate in the process. And those incentives ensure that apart from the requirement of the offender being willing to accept responsibility, the incentives also ensure that the offender is willing to participate in the process. And that reduces the likelihood of the process being protracted.
Thank you very much, Dr. Bello. I would like to hear the views of Tim Chapman on this. What are your thoughts? I'll repeat the question.
Yeah, no, okay. I think I understand. I would agree 100% with what Dr. Bello said. In our system, the person accused must admit responsibility, must plead guilty. Either tell the prosecutor that he or she admits to the offense, or the judge enters a plea of guilt, and then the case is adjourned for a conference before sentencing. And the judge, as I said earlier on, is influenced by the result of the process, what the conference has decided, and the conference will decide that the perpetrator of the harm must do these actions in order to repair and make amends to the victim, but also to do these actions to reduce the risk of them harming somebody else. That is presented to the court, and then the judge will make an order supporting that, and it becomes an enforceable supervised order in my jurisdiction. So I think it can be done, as Dr. Bello said, at any stage of the criminal justice process. Those, just to touch on the earlier question, I'm doing research into victims of serious crime who have done restorative justice, and those are mostly post-sentence and often take place in prisons.
Okay, thank you so much, Professor Tim Chapman. We'll move on to the next question, which is for Mrs. Cole. Will mental health be considered in implementing restorative justice? Mrs. Cole, please.
Yes, please, Mrs. Sojo. will mental health be considered? Well, that's an angle that the multi-door is looking at bringing in. I'm sure the Hope, Restorative Justice Hub, will also consider it. It depends on what you're asking. Will mental health be considered? Definitely. I'm not sure if I should be providing conjecture on what your question is saying, but we will look into whatever issues have arisen from the offender's perspective or victim's perspective regarding their mental health. We're looking to work with psychiatrists and clinical psychologists to find out really what caused this. So, but we're not going to do this for every offender. That's why I said we're working with the professionals. So we're hoping that they will provide guidance on possible things to look out for during the restorative justice process that will indicate that there is a mental health issue. So restorative justice facilitators are not mental health practitioners. So that's why we need those mental health practitioners to come in and say, you know, this is what we should look out for. Or if a restorative justice facilitator believes there's an issue of mental health incapacity or capacity, they can call in the psychologists or psychiatrists. So that's what we're looking at. Of course, this is all part of the brainstorming we're doing. I'd like to hear from Professor Chapman. Is there any angle on this from your end?
Thank you, Mrs. Cole. I would just add that obviously one of the things that a practitioner will be getting assessment and will maybe seek assessment from expert psychologists is the perpetrator, and for that matter, the victim, mentally capable of, you know, participating in a process, or will that process re-traumatize them or be bad for their mental health? So that would be the first thing in terms of assessing any risks involved in proceeding. The other aspect would be if either party is suffering from mental health problems, they could be invited to bring their psychologist or their social worker to the conference in our system, and that person could offer their opinion at any stage of the process. And what may come out of a conference in our system is that part of the agreement is made is that say for the sake of argument, the perpetrator of the harm receives further mental health support in order to reduce the risk of further crime. So I think mental health is increasingly a factor in anything in relation to the rehabilitation of offenders.
Sure. Thank you.
Okay, thank you so much for that angle. So we go next to the question, can we have, this is for Dr. Bello, can we have the police area commands in Lagos that have been designated as restorative justice centers? Hello, Dr. Bello?
It is not, yeah, they have not been designated. I just mentioned that 5 divisional police officers from 5 divisional police offices were trained on restorative justice. I'm not aware any area commands or place has been designated.
Okay, thank you very much. So the next one says, can I have clarification as to whether an alleged offender must necessarily plead guilty to participate in restorative justice program, and why? I would like Professor Tim Chapman to please.
Yeah.
Give us an angle.
Yeah, I think it is necessary that the offender admits guilt to the offence that's been caused to the victim, because the main thing you want to avoid in any mediation or conference is an argument about whether somebody's guilty or not. That is not the purpose of restorative justice. Restorative justice starts from the position of harm has been committed, somebody has suffered, somebody has perpetrated. Now let's talk about how we can repair the situation to everybody's satisfaction. You can't do that if one person is saying, I didn't do it. I want to argue that that is not a restorative dialogue. That is a dialogue that is suited for the court and for lawyers. And it's beyond the competence of restorative justice. So I think it is very important that the perpetrator admits full responsibility for doing it. They may not take full responsibility for, understanding the harm that's been caused to the victim, because they're there to listen to that. They can't know that in advance, but they need to at least say, yes, I did it, and somebody has been harmed, and I'm willing to meet the person who's been harmed.
Thank you so very much to all our speakers for the question and answer session. At this point, we're getting towards the end of this webinar, and I'll be calling on my Lord, Honorable Justice L.A.M. Folami, to give a closing remarks. Thank you, my Lord.
Thank you, Busola. Good afternoon to all participants. Well, I've been asked to propose the vote of thanks on behalf of the Lmdc. So on behalf of the Governing Council of the Lmdc, headed by Honorable Justice Pedro, as well as the management of the Lmdc, headed by Mrs. Achere Cole, the acting director of the Lmdc. It's the management that put together this wonderful webinar that we've had this afternoon. And I'm sure we've all learned a lot and we've benefited immensely from this webinar. I know it's not easy to find 2 hours in the middle of the day to set aside to participate in a webinar like this, but it must be because we felt that this is a very important topic to discuss. So I want to thank us all for engaging in this conversation on restorative justice, and we're going to keep the conversation going. That's the Lmdc. We'll continue to have webinars of this nature and programs, different programs on restorative justice, because we believe that it's the way to go. So I want to thank my Lord, the Honorable Chief Judge of Lagos State, Honorable Justice Alugba, without whom we would not have been able to host this webinar. We thank you very much, my Lord, for the permission and also for your attendance. We also thank the Honorable Admin Judges. I don't know if they're still with us. Honorable Justice Taufikat Oyeko Abdullahi, also Honorable Justice Oluwatoyin Ikpaye. I also want to thank all the Honorable Judges from Lagos State who are still here with us this afternoon. And in particular, I want to single out Honorable Justice Jose to give her thanks, because she was a very helpful part of the team that put together this webinar. My Lord, I want to say thank you to you most especially. I also want to thank the Honorable Attorney General, ably represented by Mrs. Oshinusi, and also his team. I want to thank the directors and the council from the Ministry of Justice who are still here with us this afternoon. We thank you very much for all that you do towards restorative justice, and we want to continue to collaborate with you. I know that members of all the other stakeholders, like the prisons, I'm sure they're all still here with us, and the police. I want to thank you very much for your participation. Of course, I will not leave out our esteemed speakers for sharing their wealth of experience with us this afternoon, starting with Honorable Justice Pedro, the Attorney General, ably represented by Mrs. Oshinusi, Mr. Akim Bello, and of course, Professor Tim Chapman. Thank you very much for sharing your experience. And then I want to thank all the participants for participating in this webinar. And like I said before, for engaging in the conversation that surrounds restorative justice, and also for participating in finding a way forward, finding solutions on how we can do this better. So especially we're talking about our practices on restorative justice in Lagos and in Nigeria as a whole. So we're going to continue. This doesn't stop here, like I said. So I want to thank us all for participating. And I hope when we call on you again, you'll join us another time. Thank you very much and have a good afternoon. Thank you.
Thank you very much, my Lord. Honorable William Folami for that closing remarks. And then we've come to the end of this webinar. We thank everyone for joining us. And please contact us on the phone numbers and the email address that has been sent on the group chats if you need further inquiries or collaboration on what has been said today. Thank you very much, and we'll see you next time.